Yeah, want to make sure.
I tell you, I ran into.
All right. Good morning, everyone. Please find your seats or stand. All right. Good morning. I would like to call the Will County Board Executive Committee meeting to order at 10:15 this morning. And Mr. Thornton in the back, would you mind standing and leading us in the pledge? Thank you. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible with liberty and justice for all. All right, thank you, Dave. Can we have a roll call, please? I got it.
Richmond, Williams, Butler, Freeman, Hickey, Logan, Newquist, Oxley, Pretzel, Trenier, Winfrey, Van Dyne.
I am here.
You have a quorum.
Thank you. Looking for a motion to approve 26-5121 Executive Committee meeting minutes of July 9th. Motion Hickey, seconded by Winfrey. Discussion on the minutes. Roll, please.
Richmond, Williams, Butler, Freeman, Hickey, Newquist, Oxley, Pretzel, Trenier, Winfrey, Van Dyne.
Yes.
Motion carries.
Thank you. Looking for a motion to approve 26-5272 Executive Committee minutes for the special meeting we had on July 28th. Move, Oxley, seconded by Winfrey. Discussion on the special meeting. Can I ask for a roll? Previous? Second? Mr. Butler, you remain a no? Yeah. Okay, roll call, please.
Richmond, Williams, Butler, Freeman, Hickey, Newquist, Oxley, Pretzel, Trenier, Winfrey, Van Dyne.
Yes.
Motion carries.
Thank you. Is there anyone from the public wishing to address the executive committee? Public comment? Seeing none, thank you. We have no old business, so we'll move into new business. Old business, Mr. Butler.
So the reason that I did not approve the minutes from last meeting was because I believe in that meeting, there was supposed to be on the agenda something from the state's attorney, because I questioned the way the process for the wetlands was handled and the special use permit. And then you said that you would put it on the agenda for the next meeting, and I think you forgot. But if you look at the video, there's discussion in there about that.
Okay, yeah, maybe it did slip my mind.
I would like to take the opportunity to address that.
And this was supposed to go on executive committee?
Yeah.
All right, go ahead and address.
So I just want, to talk about the restoration of farm wetlands in Will County. And I want to know, I believe that there's at least 13 acres of wetlands that were in question. I'm trying to get to the bottom of it, but the historical conversion of wetlands for agriculture in Illinois is my first point. Many wetlands in Will County were historically converted to agricultural use consistent with Illinois and federal policies encouraging the reclamation of swamp and overflow lands for farming. These conversions often occurred under such acts such as the Swamp Lands Act and were related state statutes. With land conveyed or repurposed under this, the premise that these lands were to be used exclusively for agriculture. Legal conditions and public policy supporting agricultural use. Illinois law and public policy have long recognized the importance of maintaining agricultural productivity on such reclaimed lands. These conditions and policies effectively restrict wetlands initially converted for farming from being used for unrelated commercial, industrial, or residential purposes without proper review and authorization. Under Illinois law, including statutes regulating wetland protections, land use, and county zoning, counties retain authority to enforce land use consistent with original conveyance purposes, agricultural preservation goals, and environmental regulations. Will County zoning and land use ordinance, aligned with state law, mandate that previous farm wetlands continue to be used primarily for agriculture, and if not, allowed to go back to their original state. So I feel there needs to be an enforcement of this, and any use of historical farm wetlands in Will County for non-agricultural purposes may violate these legal conditions and policies, undermining prior land use commitments and potentially harming public interests. Accordingly, the Will County State's Attorney should investigate any suspected and unauthorized non-agricultural use of previously farmed wetlands to ensure compliance with Illinois law and local land use regulations. And I understand that this can be confusing because a lot of these laws happened over 150 years ago. But if they're not going to be used for farmlands, they should be restored back to wetlands. Also, we've had reports on the short-eared owl being on some of these lands that they're going to turn into solar fields. Was that ever investigated? You know, I just feel like when we had the special use permit and we were told that all the agreements with the road commissioners had not been met, and the good faith clause did not include road commissioners that were talking to them but had not come to a conclusion on, you know, an agreement, that didn't include them. So therefore, that part of that contract wasn't done. And any undisclosed or undelineated farmlands must be delineated before we approve that. And when I asked about it, I was given, okay, you're right. The good faith clause doesn't include all of them. So at least the ones that we're talking to them should have been finished up before we approve that. And then to say that the young lady that was working for land use was an expert, did she call herself an expert? Did she say she was an expert? How do we determine she's an expert? I feel that if we have the state's attorney's job is to tell us how to interpret that ordinance. And I don't think there's been a proper investigation here, and I'm calling for it. And I called for it last month, and I'm calling for it again. And I think we should get this thing resolved before this lawsuit that is inevitably coming, it comes. So I do have a resolution that I will present to the board. I'm not going to read the whole thing now, but maybe we could get it on the agenda.
I'm gonna go back and check the minutes to see what I actually agreed to. If you can give me, if it was last month in executive committee, I will review that and
Yeah.
see. Because it might have been a
We'll
slip.
do it next month, and I said, I'm going to hold you to that.
Okay,
Here I am.
all right,
I'm always good for my word.
yeah. I seem to think that I am too, so maybe it was a mistake.
That's why I said you forgot.
Yeah, thank you. Okay. Proceed.
Okay, so I don't know if you want me to read the whole resolution or just submit it for, you can make copies, but basically it's, I just feel like I kind of explained the whole thing, so I don't really want to read the whole thing and, kind of rehash it. But I gave you the basic grounds that I felt like this should have been investigated. Do you want this submitted for a special meeting, or do you want, like,
Well, I would think in order to approve it through the executive committee, that it would have to come now.
okay?
If that's your intention to bring it to the full board next week, then you might have to make copies and submit it to the board members or the committee members and let them peruse over it and read it before we vote to push it to full board. If you're willing to wait until next executive committee, then I'll have time to review the minutes, and then it'll give everybody time to read your resolution and mark it up whether they choose to or not. And I mean, however you want to try to handle it.
Okay, so I do feel like there's a sense of urgency because as I went to the land use department, I found out they've already tried to push the permit through once, and they're going to be trying to push it through again. I'm assuming that they couldn't push it through because, maybe they didn't have some of these things done, but I do think there's a sense of urgency here.
I wouldn't say that the land use tried to push it through. I think
I meant
they
the
give
the solar company was trying to push it through.
Oh, the solar company, because I think the land use pushes it through with the approval of the full board. So, yeah,
Well, they won't come back to us at all. This is the solar company trying to push it through as quickly as they can. It didn't pass. So I'm assuming that the land use department did their job and they did not have the things that we're talking about done. But I still, I want to take action before it's too late.
well, let's see how you want to proceed. If you want to make copies and pass it out to the committee members and have them vote to save space on next week's full board, it will be up to the committee. If it passes, it'll make it onto the full board. If not, then it will have to probably be considered for next month at executive committee. So how would you like to proceed?
I guess I would like them to vote on that.
Today?
Yeah.
Well, we would have to save space on the agenda,
Okay.
on next week's agenda for this item.
Okay.
So it would be up to the committee whether they want to save space for that item or not.
Okay.
So if you want to take that path, then we're going to have to get copies to everybody on the executive committee. And as we proceed, there'll be an opportunity at the end to save space, and we'll see what the committee decides.
Okay, thank you.
All right. And we'll have staff make that copy.
Okay.
All right. Thank you, Dan. All right. Is there any other old business? Member Ogala?
Thank you. So last month, I remember at the July 9th Executive Committee meeting that Member Richmond had made a motion to add an agenda item to the Finance Committee for an item to move $260,000 from cannabis to the clerk's budget. And that didn't appear on there. I thought maybe then would have come here. Can you tell me the background on what's going on with that? We made that motion and was voted on.
Once again, I'll have to review that. I don't,
Your chief of staff should know this answer. My chief of staff knew. Would know, for sure. My chief of staff kept good notes.
oh, you mean Chuck Pelkey? He's your chief of staff.
My old chief of staff kept good notes.
Our-
And she knew.
Our chief of staff?
All right, let's debate words. Yes, the chief of staff should know that. We voted on it. This board voted to do that. Didn't show up on the finance committee agenda. It's not on the executive committee agenda. I'm just like wondering where that is and what's happening with that.
And say again, the 260,000?
$260 from cannabis for the clerk's budget. From the clerk, move it to the clerk's budget for the, for the folding machine.
Okay. Well, can I have the
Mail-in ballots.
state's attorney and chief of staff, please
Julie, can you plug me?
enlighten us?
I would have to come and check my notes as well. And, you know, Jackie, you keep notes as well, detailed notes. I don't recall the vote on it. We'd have to go back and check them and then also check the minutes from that meeting as well to determine whether the vote, that vote actually occurred. If there's a vote on something, you know, we typically move it forward, so.
I would say, Joe, I don't have anything to add to that. Chuck, it's just correct. We have to check the record to see what happened. I don't have any independent recollection of that.
Okay.
So I know there was discussion, but I don't recall a vote. Or I don't recall if there was a vote.
Okay. Well, I don't know if that's the answer you want to hear, but I guess we gotta go back and investigate once again.
Okay.
All right, Mr. Oxley, old business. Let's have it.
Yes, let's have it. Speaking about Ms. Agala's comments here, that was originally voted on when we divvied up the money with the cannabis and everything. That was voted on by this full board before last month's meeting. Then last month, I believe it was brought up again, but shouldn't need 10 votes. We voted on it once before to approve those expenditures. It should have been taken care of long ago, not today.
Thank you. Any other old business? Seeing none? All right. We will investigate that as soon as we possibly can and try to get an answer. New business, 26-5311, resolution regarding the role of the county in the annual tax sale. Is there a motion by Winfrey? Second Hickey? Discussion? Mr. Oxley.
Thank you. First and foremost, I would like to see a list of the properties that we have the proposed expenditures for, the 2,000 properties we're talking about, with the assessed valuations of the properties. And then if you take 95% of the 2,000 parcels, they're not houses, they're all parcels, because some are detention ponds, some are flower pots and cul-de-sacs, stuff of this nature. It's only 100 parcels. So the figure of $10 to $12 million just doesn't add up. So I think to make an educated decision, we should all see a list of the properties, the assessed valuation set by the assessor's office of these properties and the value before we make a decision to move money from one place to the next, and wait until it happens. Because this is a 2 to 3 year process, as we've been told down the road, that the person that their property is sold and doesn't get the equity has to sue us for it or file suit. And it'll take 2 to 3 years in the court system. Then we can move the money. Why would we move money today and lose all that interest at $10 or $12 million, which I don't think that figure is accurate? And we would lose all that interest for 2 or 3 years. And then was there a fund set up a couple years ago before I was here for this? Did Mary Tatro set up? I was told she did, but I don't have any other information than what I was told.
What's the correct term of the fund? And I think they're down to about $60,000 in that fund, somewhere in that ballpark.
I guess that's a question for the treasurer or the accounting. I'd like to see it. I'd like to hear it from our head of finance, how much is in that fund. But still, I'm asking for a list of the properties, the assessed valuation of the properties, and then we can determine the exact potential thing, because it's hard to believe that somebody buys a detention pond for $145 and it's worth $400,000
Can I?
Yeah.
of equity.
Good morning. So we're talking about where there's two separate tracks of properties. So we have the 75 to 80 properties that have already went to tax deed. It means the private buyer already has the property. That is the calculation from the treasurer's office based on what the sale price was, minus the taxes and the interest and the penalties that were accrued, is where we came up with a figure of between $9 and $11 million in possible risk on those 75 to 80 properties. Those 75 to 80 properties are not retention ponds. They're not little strips. those properties are held by the trustee. Typically, the tax buyers do not bid and get retention ponds, little strips of property. Those are the ones that are held by the trustee. The trustee there is a separate list of the properties that are held for the trustee. We are not concerned about those because we are holding the surplus on anything that goes on those properties. So if the trustee had a property in the last 2 or 3 years that has been sold, we have held on to the equity. We're still holding that. We don't have to pay claims on that. We've already got the money set aside for that. The properties that we're talking about, when I spoke about at the committee of the whole, those properties have already went to tax deed. Member Richmond and I have others have a list of these properties for you to review. He has it right now. In fact, he gave it to the 70 to 80, that chart.
Do you have that list?
Yes, and I showed
when
it to
did you
Member
get it?
Richmond at an earlier time, but we were able, I needed to get it done. It was too big. The Excel sheet was quite big. I don't necessarily want this list generally distributed because it's a risk list for us.
So then we
But
should be
you can't-
discussing this in executive session then.
Well,
I mean, I'm not going to vote to take 10 or 12 million dollars or 9 to 11 out of one fund and put it in a special fund without knowing what I'm voting on.
I'm being told that the list was sent out to all the county board members on 7/15/26. Continue.
Anybody get it? When, Jim? I just got the list. A few minutes ago, not a month ago.
no, but Member Richmond saw the list. He actually, you got a scaled down copy of it.
Well, I can see the newspaper, doesn't mean I read it.
Yes, yes.
All right, bottom line, Mr. Oxley wants to see a list before he votes.
Absolutely.
All right,
This should not be on the agenda till everybody in this room that has voting capacity sees it and makes a rational decision. Because it just seems like something's going on here.
I don't
like it one bit.
I don't
You
know.
want me to vote on $9 to $10 million of taxpayer money to throw in a fund to sit for 2 to 3 years, making no interest? It's not going to happen.
Well, let me just say this. So the resolution that we're talking about doesn't have anything to do right now with funding the surplus equity fund. So if there's some confusion about that, I apologize. We're not talking about voting on adding money to the surplus equity fund at this point. The only thing that's really being talked, there's 2 things that are being done. We're asking that the treasurer be allowed to collect a fee, which will add money to the surplus equity fund. That's one resolution that is up this month. And then the second resolution is for the board to make a decision to have the county step into the role of which has been previously held by the private tax buyers, and that actually the county tax agent as your proposed agent in handling these properties, be the one to administer the tax sale auctions, administer the properties. And we believe that there's cost savings in doing that. The trustee is currently doing it on the non-sold properties that are done at the tax sale now. It'll save in a reduction of the sale in heirs, which can cost interest to us. And we also have a little bit better control over the auction process. The county tax agent's been, as he explained, the committee of the whole has a pretty good track record of turning the retention ponds and some of the lower properties into getting them back on the tax rolls. And he would just continue to do that process for the properties that are, the homes and maybe something of more value. But the voting for putting money into the surplus fund is not something that's up right now. And so the list of the properties for that, is going to get around, but we're not asking for any action on that yet. That's for the budget. So you should have that information, and I am certainly available to anybody here that wants to come and meet with me, and I can walk them through the process. My door is open. I'm the one that handles these tax cases. That's why I'm here today. I'm not normally here. I want to answer any questions so that everybody has a full understanding of this process. And trust me, I understand it's a complicated process. And there's a lot of moving parts. There's Supreme Court cases. There's new legislation by the state that redoes this process. So as Mr. Myers indicated, the putting the money in the surplus, that's not what we're dealing with currently.
Well, Scott, you'll have to excuse me if I misspoke or got out of line there.
No.
My computer literacy skills are slim to none, and I'm still having a problem here getting this thing, whatever they call it, to show the item on the agenda. The cover sheet is, I'm messing with to see it, but I just, moving forward, I want to see this stuff before I vote on it. Because I have people to answer to, as everyone else in this room does. And I have seen detention ponds sold at tax sales. I have seen 33-foot by 600-foot strips of land sold at tax sales. I have seen claims come up 2 and 3 years later for it. So it does happen.
The private tax buyers sometimes do
Yes.
not do their research like they should, and they end
Yes,
up buying
yes.
something that they shouldn't.
There's
Yes,
companies
that
from
happens.
California that come and bid it at 3% and pay it, and the interest rate doubles because the state of Illinois is a bid the interest rate. It doubles every 6 months. They are required to pay the fees to redeem the owner of the parcel. Jewel in Lockport, Walmart, everywhere, their detention ponds, separate tax number because they don't pay the taxes and people buy them. So what are we talking about for the parcels? Where are they? I want to see a list of them with the assessed valuation. Thank you.
Yep. Thank you, Mr. Oxley. Member Trenier?
Thank you, Speaker Van Dyne. Actually, that was going to be my query. I thought we were voting on resolution item number 1, which has nothing to do with moving money. And I did get the email with the properties. I didn't actually open the attachments because I was here for the discussion and didn't really have any questions, didn't need to see a list. But apparently maybe now I want to look at the list. But it is here. I saw the list of the properties. What I couldn't get to open, I think, was, the Excel sheet that actually, no, none of these give a price. I wasn't wrong. I did look at it correctly. Gives you the address, the lot size, inspection, the township that it's in, et cetera, but there's nothing here about what it might be worth. So I've been in real estate, but I wouldn't even begin to think that I would have time to go out and inspect all these properties and come up with some kind of valuation. So I'm not sure who's helping the state's attorney's office do that. If Mr. Glasgow has already done that, or is someone else going to be doing that? How do we know what they're worth? Are we using the EAV from the supervisor of assessments? Or are we using an independent inspection, audit, whatever, to determine the market value?
Mr. Speaker. So again, we're talking about, there's 2 different sets of properties that we're talking about. One is a list of 2,000 open certs, which are the tax sale certificates that have been purchased at prior annual sales that have not gone to tax deed. There is a list of those properties that's available. Those properties we don't have to be as concerned about because we are going to be doing a process of declaring them to be a sale and error administratively. So all those 2,000s, the treasurer's office is going to send out something indicating that those are sale and errors. There are grounds now under the new act for these to be declared as a sale and error because they are just a prior tax certificate. The reason we're declaring these to be sale and error is that we want these properties now to go under the new system, with the new system protects the prior homeowner's equity and also requires an auction. So there is no direct title transfer on these properties. As for the other list, which is the 75 to 80 properties, so a lot of those properties have been sold. Those went to tax deed. The tax buyer has already sold those properties. So we have the value figures.
That list is not here.
No, I know, I understand that. That is a separate list that we have that. This list was prepared by the treasurer's office in response to discovery in the federal court case that I talked about at the committee of the whole, the Sheriff versus Henry case. So this list is there and it's in existence, and we will get a copy to everybody so that they can look at it.
Okay, because what I have is about a little under 500,000. The list that's here, it's the
Oh.
surplus auction results.
Yeah, I'm not
Again,
sure. I'm not sure what you're looking at.
Well, there you go. And that's the problem.
I don't know what was
So-
sent to the county board. All I know is what I have.
I don't know what this stuff is. I have no clue what this is.
What
That I'm-
was sent to the county board, and again, I clarified with the treasurer, what was sent to the county board was the Will County auction book, the list of surplus properties, and the surplus properties as of July 2026. That was sent on July 17th. Again, those are not the properties that we're talking about now. I just confirmed with
Okay,
the
that-
treasurer's office.
thank you.
But yeah, so I just wanted to clarify that, I move this stuff the minute I get it, and I try to be
Yep.
responsive to you guys
No,
immediately.
thank you. Like I said, it's very confusing because we got a board member talking about transferring money, but I don't see that on the agenda. And then there's all this discussion about why we're transferring it. Again, not on the agenda, but then we're referred back to an email on July 15th. So I'm just trying to figure out what we're really talking about this morning before it's afternoon.
Thank you. I'm starting to think that the committee of the whole was a complete waste of time with all the buttons pushed. So, Member Berkowitz.
Thank you, Speaker Van Dyne. So Scott, on the resolution that's attached, the third paragraph, it refers to Public Act 104. It goes on to say that in counties with fewer than 3 million inhabitants, a county board may, in its discretion, submit to the collector a list of any properties. So this paragraph is specifically stating that this would occur by a county board, which would be us here.
Correct.
Yet we do not have that information. We don't have the information of the list of properties that would be submitted to the collector. So that concerns me. It's indicating that we need to do something that we really don't have any control over. I believe the list would actually come from the treasurer, correct? Because the treasurer knows which properties are distressed, who doesn't pay their taxes, not the county board, correct?
Well, yes. So the treasurer doesn't know what properties are going to be distressed for the current year right now because the
No.
property taxes are not
Well,
due
let-
until September 1st.
Right,
So
let's
we
not
don't
jump
have a
ahead.
list yet.
Let's focus on this resolution. This resolution is stating that the county board may at its discretion submit to the collector. The collector, who is the collector?
That's the treasurer.
So the county board is going to submit to the treasurer. That doesn't make sense to me. We don't get the tax, we don't send the tax bills, we don't get the tax payments. And this just may be legal jargon, but it does not make sense to me.
Well, I'll try to explain it. So let's go back a little bit in the process, and I'm kind of repeating what I said at the committee at the whole. So the treasurer sends out tax bills for the prior tax year. So this year, we are collecting the taxes for the 2025 tax year here in 2026. So those bills are paid, there's usually two payments. One, I believe, is due in June and one is due in September. So we don't know at this point the properties that are going to be in distress on the basis of the taxes because the bill is not due yet. So the treasurer will compile that list of properties. In the legislation, Cook County is they made an exception for Cook County, which is why they made the distinction about the population. Cook County is only allowed to put 100 properties into the county, so they can choose which properties they want the county board to act as the trustee for, and then the rest of those properties are up for auction or at the annual sale to the private tax buyers. So the private tax buyers are going to continue to have a role in Cook County for the next several tax sales. That is specifically in the statute. Cook County they're doing a pilot program to test that. We are not included in that pilot program. So the resolution, and it's again, and as I stated at the committee of the whole, this is a decision that the county board makes. And the county board, in my opinion, is not going to need a list of exactly which properties. It's more of a policy decision of who do you want administering these distressed properties. If you want the private tax buyers to continue, that is a choice the board can make. Well, we want the private tax buyers to continue to come in and bid on the tax certificates, and they will receive a higher rate of interest on the auctions. The sale and error process, on which the treasurer has to pay interest if they come in and say that there was a defect in the tax certificate or in the documentation that was done. And then those property, we would refund it with interest back to the tax buyer, and then it goes up for sale again at the next tax sale. That's the process that we're currently using now. The new act, however, provides that if somebody does get a tax certificate, they do not get a direct title transfer if they do purchase that tax certificate. They now have to apply to the court to get an auction. They have to hold an auction, and then the winner of that auction takes the title of the property, which is different from what occurred before, when if somebody bought a tax certificate and the property owner did not redeem, they would just get the title to the property. And that's where the issue with Tyler was, because the homeowner would be losing their equity if they did not redeem, and the title then went to the private tax buyer. The statute gives us two tracks. We can continue with the private tax buyer, or we can go with you acting as the trustee and letting our county tax agent handle that process. Yes, you're correct. The list is going to come from the treasurer, but my recommendation is just for the county to take over that role, because it'll be a cost savings not only to the county, it'll also be a cost savings to the prior homeowner, because we will be in a better position to control the cost. The interest that is due on the tax certificates that are held by the trustee is at a set rate. It's not bid, it's a set rate by statute. Private tax buyers can get up to 18% interest. The county is limited to a monthly rate of 0.75 interest. So we feel that having the trustee, or for the county board to make the decision for the county board, the county board to be the trustee of these properties, and then to turn that auction work and the redemption paperwork over to the county tax agent is the route to take. And we are allowed to do that under the new act. So the resolution that you have describes the statutory process that's involved and how that occurs. Because you as the county board are going to have a list of properties that are going to tell the treasurer, we don't want these pins to be sold to private tax buyers at the annual sale. The resolution is essentially saying we're not going to have a private tax sale. The county is just going to acquire, and I'm using the term loosely because we're not taking title to these properties. Eventually, whoever wins the auction is going to get the property. And the auction, which is again statutorily regulated, will require that the minimum bid at these auctions be the amount of the taxes and the redemption. And then any money over that equity would then be deposited with the treasurer so the prior homeowner can make a claim. And we have, as the county taxation person that you hire to do this work, will be in control of that process, as opposed to the private tax buyer would then let the sheriff do it. And we just think it's just a better way for us to manage this if we did it that way. And that's what we're asking. So it's not a matter of telling the treasurer what, or how we get that information. The treasurer is going to tell us the pins that are going to be distressed. You would look at that list and say, well, we want these pins we want all of these pins to be acquired by the county to use at the tax sale, and that we would be the purchaser, quote unquote, of those things.
Scott.
So that's the basics.
Scott, and I agree. I think every homeowner should get their equity from their property. I don't even think these taxes should be linked to their ownership of the home at all. We really don't have true home ownership under this system. But here's a question. Can we, the way you've described it, it's possible that a house is sold, private buyer picks it up, and none of the equity is recovered. Can we sell the homes? Do we have any ability to sell these homes at a price which covers the equity that the homeowner is entitled to? That they should always get their equity. Do we have that ability?
So under the old system, no. If the private tax buyer holds the tax certificate and the property owner does not redeem, the private tax buyer goes to court and applies for a tax deed. Full stop.
But the new
And there is
system.
they get title of the property. There's no to set aside for the equity. That is a situation that is involved in the 75 to 80 properties that are currently have been issued a tax deed. That's under the old system. Under the new system, anytime that there is a tax certificate, it must go to auction. There is no, we can't, under very limited circumstances, I think that the trustee sometimes has made deals, but this new statute, the new statute requires an auction. It has to be a publicly noticed auction. It has to meet certain requirements. Frankly, the old homeowner can go in and bid on their own property. Anybody can bid at these auctions, including the tax buyers. The tax buyers will have a role. They're just going to be acquiring these properties at an auction. And then they will pay the price that they'll have to pay. The minimum bid at an auction will cover the tax and the penalties and the interest. Any amount of money above that it goes to the treasurer so that they can, the prior homeowner can make a claim for that equity.
So my question is, can we set the sale price, the beginning price, to include the equity on that property? So we guarantee that this person who was removed from their house at least gets their equity. Can we do that?
Well, so there's a couple things to that. So the question becomes, what is the equity? So we have a situation where somebody is not, they have not paid their taxes for
So,
3
excuse
years.
me,
They
like
haven't.
Every mortgage, there's a principal paid and interest. You know what your principal is that you paid on that house.
Well,
It's
but
part of a mortgage.
none of these properties have a mortgage generally, because the mortgage company is paying the taxes. You're not, these properties that we're talking about here don't have mortgages because the mortgage company makes sure that the taxes are paid. Otherwise, the bank's going to lose the property at a
But
tax
the
bill. They don't let that
homeowner
happen. That's
is
why you have an
still
escrow account.
paying a mortgage.
Who's paying
When
the
you
mortgage?
have a mortgage, part of the payment goes, very little goes to equity, and then you have interest. You want to pay down your mortgage, you put more towards your principal. So if somebody owns a home for a year, they stop paying their mortgage, the mortgage company takes the property. There's still a record of payment there. There's still a record of dollars that went towards principal and dollars that went towards interest.
Julie, that agreement is between the person purchasing the home and the mortgage company. If they don't follow, if the homeowner does not follow the agreement and pay in full after 30
Look.
years, the mortgage company takes over.
What I'm saying is this system is not fair.
Well,
And I just want to know if we have the ability to make it a little more, well, it's never fair to the person who lost their home, but do we have that ability? It sounds like we don't.
you can set a price for an auction, minimum price.
That was the question.
If you,
Is that
if you
true?
do, it might not sell. Like if you want to try to get equity back to the homeowner, it might not sell. And then the trustee will just take the property and it'll
So you
remain off
just
the tax roll.
answered my question.
I
that
just tried.
was- you just said, yes, we can set the price.
Can we
Thank
set a
you.
minimum price at an auction?
Yes,
Okay.
but
Thank you.
but the minimum price is set by statute. The
There
minimum
you
price, the
go.
minimum price at an auction is the amount of the taxes, the interest and the penalties. So
There you go.
Yeah.
All right.
All right, thank you.
Let's,
That was the
we got a
answer
lot
to
of
my
lights on.
question.
Let's move to Ms. Ogala. She here? Okay. She needs another cup of coffee.
I didn't have a cup yet. Thank you. First off, Joe, I want to say, I do not think that the committee of the whole was a waste of time at all. I think it was very beneficial. I think the issue is that this is very complicated and it's a lot of information. And after I left the meeting, I had a lot of questions myself. So I understand we're trying to just do the resolution for allowing the county to be in the tax sale. So I just need this clarification. We've been the trustee all along, haven't we?
Oh, yes, we
Okay.
are the last, I guess, the appropriate way, we're the bidder of last resort. So if somebody does not place a bid on a parcel, that parcel goes to the trustee, correct?
Okay. And we've always had this company that we're going to continue to use, but just in a different manner. Instead of setting up the tax sales that would be in this room with lights going on and buzzers and flags and everything, we would do an auction instead. Not we, they would.
Not at the annual sale, no.
So the annual sale would still go on for taxes.
No, not really. We would be the only, if the county board adopts the resolution that I'm suggesting, the county will be the buyer of all the properties. So there might be an auction, but we're the only one that are going to be bidding. I mean, technically there might be a sale, but you're going to be indicating, the county's going to be acquiring all these tax certificates. There'll be no private tax buyers.
Right. So there'll be no room where everybody's filled in buying these properties.
That's correct.
That's what I tried to say. Okay. So then I have a question here what fund would any of this go into? What fund would like that? Equity fee fund fee coming up? What is the name of that fund?
So, are you talking about the surplus equity fund or are you talking about the one?
That's a new one, the surplus equity fund?
The new legislation creates what's called the surplus equity fund, which starts a fund that would allow us to refund people that had lost money from a tax sale, that will allow them to get their equity back. They'd have to make a claim for it. And then they would receive an award from the court for that equity that would be paid out of that fund.
Out of the surplus equity fund?
Yes,
So that exists today and it has some money in it?
No,
No, okay. I wanted to verify that.
it just started, it was just, the statute in July just passed it. There's no money in it yet because we haven't been collecting any fees for it yet.
Okay.
That's another resolution that we're asking the board to allow treasurer to start collecting a fee for that.
I see that. Okay, that makes sense to me now. So when Mary Tatro was here, when this first court case came out and we talked about it and everything, she had us move money, I believe, into the Tort Immunity Fund.
No, what we did there was, so there are kind of two methods for people to recover the equity loss at a tax sale. First is the indemnity fund. And I think maybe that it's a different fund from the Tort Immunity Fund. It's an indemnity fund. And there are fees collected from the tax buyers that are supposed to go in this indemnity fund. So people that lost their homes in tax sales have for years had the ability to make a claim for their lost equity from this indemnity fund. And the fund existed, it was kind of a subpart of the Tort Immunity Fund. And so the claims were paid out of the Tort Immunity Fund. That was my understanding of how it was done before I was here. When I came in and saw this, I wanted the funds split. I wanted the funds for the indemnity fund separated from the Tort Immunity Fund, because in handling these claims, it's an issue of how much the indemnity award would be if it went to trial, is how much money is actually in the indemnity fund. And if the indemnity fund was held the same way as with the Tort Immunity Fund, I would be less of a defense, one less tool for me to have at trial to defend the county. So I had it split. That indemnity fund, by the way, is still in existence. My understanding from the committee at the whole is that there is $160,000 in that indemnity fund. Having said that, I recently settled a case for $99,000 on an indemnity case that I think is going to draw that down. And I would say there are 4 or 5 of those indemnity claims that are pending now that I'm working on. I typically depose because I want to find out why they lost their home and do an investigation of what happened. And typically we'll make an offer just to give these people some money out of the indemnity fund. That has been in existence, and it's still in existence in conjunction with the surplus equity fund. As I explained at the committee of the whole, however, people are going to be limited. You either got to choose. You're either going to get an award out of the indemnity fund or you make a claim out of the surplus equity fund. They can't double dip.
Okay, so the surplus equity fund, is that where this fee is going to go to?
The surplus equity fund was created by the new legislation, the 104-0553. That's the
Okay.
new act that requires all properties to go to auction, and any equity that is at these auctions must be given to the treasurer for claim, so that the prior homeowner can make a claim.
Okay,
And I believe that is number 2 on our
Right.
agenda, correct?
yes, I see that.
Yep.
It's just all kind of together to me. So we had an indemnity fund for a long time, and that was in the Tort Immunity Fund, and you split it.
Yes,
Okay,
I wanted the indemnity fund separated from the tort immunity fund.
okay. So I know we're not talking dollars here, but the budget's coming around the corner. So where are you thinking of this money that you'd like to get out of case reserves? Where are we putting that?
So the indemnity fund has there are fees collected by the treasurer at the tax sales or whenever there's participation by the tax buyers. There are fees that are specifically supposed to go to the indemnity fund. So it's not a matter of you having to appropriate fresh money. There are fees that are collected that's supposed to go into that fund. So that's number one. Number two, there's also going to be money going into the surplus equity fund once you approve the $20 fee. If you approve the $20 fee, that'll start funding the surplus equity fund. And there are other things. If somebody takes a tax deed or private tax deed gets issued, they have to make a payment that's non-refundable into the surplus equity fund as well. So there are some funding mechanisms in the new bill that are adding money to both the indemnity fund and the surplus equity fund. However, as I stated at the committee of the whole, the funding mechanisms for the surplus equity fund are not going to be sufficient to deal with the claims that we think are out there. So that's why I asked, in terms of the budget process going forward, that there be money placed in the surplus equity fund to possibly cover some of this risk. Keep in mind that there's a possibility some people won't make claims. There's a possibility that property values can adjust. So if there is money after this is gone through and there's money left, then you're not, that doesn't, like the treasurer said at the committee of the whole, you can move that money out of there and move it to something else. I just think that we need to have some money to cover the risk that the treasurer has identified on the properties that have went to tax deed and that has been turned over in discovery in the Sherritt case. So.
Okay, so the new surplus equity fund is where we're collecting the $20 fee from the tax buyer.
Yes.
Okay, the indemnity fund is a separate fund that the tax buyer has been paying fees into already.
Yes.
Okay, and what is now the tort immunity fund? That's a separate fund?
That's a separate fund to cover all the other.
Court cases we have?
Yes, correct.
Okay, that's fine. I think that's all I have questions right now then, so, okay, thank you.
Mr. Butler.
Okay, so I know that you've explained a lot, and I know you've been working on this, and you are the expert in this area. So forgive me for asking some of these questions, but sometimes these resolutions can be a little technical. And maybe for you, because you understand it, you just write it down and forget that some people don't. So let me just ask you, there's two laws that were just passed that give us the option to do what you're suggesting in here.
It's really one act.
Well, okay, one act.
But there's a lot, I will agree,
It
there's
just
a lot
says
of
and.
changes to the property tax code in the one act.
Yeah, so it lists two different parts of that act or whatever that gives us that. So we don't have to do it or we could do it. But our present way of doing it, sometimes these private buyers will make 18% interest. Who pays that? Who
That's
pays
part
that?
of, that's the prior, if the prior property owner redeems, they're paying it.
They pay the interest?
Yes, they pay
Okay,
the
so-
interest.
so
That's
that-
part of the,
so- so
if
I
they
guess-
want to redeem, they have to pay the interest and the penalties and the taxes back to it. That's correct.
So in a way, that prevented that person from maybe getting some of their equity back. So the new way allows them to get maybe a little bit better or?
No, they're going to still have to pay the interest and if
No, but I mean-
the county does it, yes, the
So that-
interest
that's
rate
what
is
I-
lower.
That's what I'm asking.
Yes.
So the old way, they actually would have lost possible, equity because of the high interest that they had to pay. But with the county doing it, we can utilize it and there's more money to be
Given back to the homeowner.
reacquired. Okay,
That's
but,
exactly correct.
okay, thank you. And I think that's important for everyone to know that there's a decision being made here, but with the risk, there is a liability. Right? Because we are acquiring these certificates and we expect most of them to be settled, but maybe not all of them are, right? But we feel that the risk reward is worth it for our
Well,
residents.
I mean, I don't really see a risk because if they don't redeem, then those properties will be auctioned. And then, as I explained to the committee of the whole, there was a case that was decided by the Supreme Court this year called Pung versus Isabella County. And see, the issue in that case was kind of a follow-up from the Tyler case. And the Tyler case said that that the equity must be returned to the prior homeowner. And then the question in Pung was, well, how do we determine what the equity is? There was a suggestion by the plaintiffs in that case that it should be fair market value. full stop, and that essentially the governmental bodies become the real estate agent of these properties, and, we're out. And the Supreme Court rejected that. The Supreme Court said that the auction price, competitive auction, fully noticed, not some insider people coming in. It's got to be a fully competitive auction following the traditional rules of auction to get what would be considered to be a market value of the property based on everybody going to having it publicized, people being able to go to look at the property if they want to see it, a picture, get a description. We have to notice all that stuff. Then they bid.
Okay, just bear with me, okay?
Sure.
Because if you go on with too much of an answer, I'm gonna lose my place, okay? So, obviously, when we're talking about having to supply a maximum of $12 million for this new way of doing things, there has to be a liability somewhere. I mean, we know that it's not gonna be 12 million because the treasurer told us that much of that would have been settled, but worst case scenario, nothing gets settled and it costs us 12 million is what he was saying. That's like the worst possible scenario.
So again, there's two separate.
I understand that, but I'm just.
The 70
I'm trying to tie in people's confusion with
Sure.
this is step one and step two comes afterwards. And I guess what I'm trying to find out here is if we accept step one and it becomes part of our way of business, is the liability outweigh the loss of equity possibly for the homeowners? Like I'm just trying to weigh it all out because we already have a system. We don't have to switch over. Is that it? And we could allow that to continue. But if we do switch over, it's better for the homeowners or the if they want to recoup some of their equity cost.
Well, the system is fundamentally changed. In my opinion, there's not going to be much of a market for the private tax buyers under the new act. Even if we didn't switch, I don't think you're going to see a lot of private tax buyer activity because the incentive is gone.
So the way I understood it was that doing it this way is actually better for the county.
Yes,
And
if
I
the
guess
county
that's
is
what
a
I
trustee,
wanted-
yes.
I just want you to explain that part, how it's better for the county than the old way. And maybe that'll help people to accept what you're saying. But right now, it's just, there's too much. Just
Sure.
How is it?
So there, so
Keep it simple.
I think I tried to.
Yeah.
How's it better?
So
Maybe I can talk in layman's terms if I say anything incorrect.
Sure, go ahead.
So the old way, the tax buyer, the private tax buyer will buy the property. And now with the new law, it's an 18% interest rate now that the previous homeowner would lose out on. If we go with the trustee way, where the county owns the properties, then when we have to redeem the tax sale back to, or when we have to redeem it, it's only at 0.75% per month that the previous owner would lose out on for the interest. So it's a savings to the person that actually lost their home.
And then what would be our liability for doing that?
What is our liability?
What, for us acting as a tax agent?
Yes.
I don't know of any liability.
Okay, well, I mean, that's the kind of things we want to know, if there is a liability or not. Because when you say that we're going to need 12 million, that sounds like we got to come up with 12 million and there's a liability. If you didn't say we needed 12 million, nobody would be.
I'm being
there was a
told
liability.
I'm not talking simple enough. So I'm gonna try to break this down a little bit easier. Yes, you're talking about the 12 million. That money is relating to the properties that have already gone to tax deed. They're gone. They're done.
Okay.
The money that I'm talking about for the 12 million, those properties have already gone to tax deed. They've already gone through the process. We know what the sale price is. We know what the taxes were. It's not difficult to figure out the math on what that liability is Those are things in the past.
Before 25.
Correct.
Okay. All right, and then, okay. All right, that's all I had. I just needed to get a few details straight in my head so I could make a
It's,
decision.
it's confusing,
Yeah.
sure, for all of us. Moving on to Leader Richmond.
I was just going to try and break it down in layman's terms. So there's no need for me to speak. So,
Okay.
but thank you.
Thank you. Member Newquist.
Thank you. I just want to clarify what we're voting on. But before I do, I want to say one thing. We, in terms of getting a list of properties that would be sold, either sold at a tax sale or acquired by the county, we basically do that now. I mean, not every month, but many months in the finance committee and then here on the board, we get lists of properties that are going to be sold at a tax sale and we approve them now. So I don't see that if we change the way that we handle the tax sales, that's not going to change at all, correct? I mean, that's just going to be business as usual. We're going to get a list. We're going to approve it in a board meeting. Am I correct about that?
That's correct. I mean, there's a process that we've been doing, that I've been doing. I have to apply to the court to sell the distressed properties at a annual sale.
Right.
I'm directed technically by you folks to do that. So that process is not really going to change very much.
So I just wanted to point out that we're already doing that. But so then in this particular resolution, if I'm understanding it correctly, what we are voting on is kind of two things. One, we are giving you the go-ahead to declare the certificates sold in error, correct? The 2,000 certificates that have already been.
Now, that's not really part of what.
That's not part of this.
That's not part of this. That's something, that's something the
Okay.
treasurer and.
So all we're doing in this resolution is allowing the county to acquire the properties versus selling them to a private tax buyer.
Going forward. This
Going
is only
forward.
talking about things that are now the annual tax sale typically takes place in December. So this December, and what we're asking for in this resolution, we're asking in this December that we not really hold an annual sale, that we essentially become the holders of these tax certificates that would otherwise be sold at the tax sale.
And that's all. It's not talking about any other process or, money. It's just literally, this is what we're going to do going forward.
Correct.
Okay, thank you.
Thank you. Member Freeman.
Thank you. And Member Newquist did just answer several of my questions, but I think I sat through the committee of the whole, and I know that money is not part of these two resolutions, but it was stated earlier that we would only need like the $11 million. That's for the 75 properties, correct?
Correct.
Coming future, the 2,000 that we're hoping will be diminished down to 90% less than that. I think that was what was said at the cow. We would need more money at that point.
There is the potential that out of those 2,000 properties, there's a possibility that there could be tax deeds issued on some of those certs.
Correct.
And that every time that a tax deed does get issued, becomes an additional liability for the loss of that equity in a future claim.
And
Yes.
then I want to just clarify one more thing. Your plan is going to eventually protect us in the future, and we would have the properties, we would not have to have surplus, but we're talking a couple of years down the road, I'm assuming, when the money in the surplus equity fund is stable. Am I correct?
Correct. And keep in mind that we won't have to make payments out of the surplus equity fund once we start going to auction, because the auctions are going to require that any equity from the sale be deposited with the treasurer. And then that person would then get their surplus directly from the treasurer. There would be no payment under the surplus equity fund. Now, could there be the remote possibility that a weird situation comes up where somebody's got his, a $500,000 home and they got an appraisal and something and the property goes to auction and it only covers 200. Could a court find that we might have to make a surplus equity fund award in an unusual circumstance? Yes. We can't foreclose that, but for the great majority, the surpluses that are going to be generated by the auctions are going to cover our risk on that. That's what the purpose of the statute is. And, we want to have competitive auctions and make sure we get information so that people, when there's a nice property, people can bid on it and that we get as much money for those as we can. And then that equity loss can then be given back to the prior homeowner. That's the object of doing it this way.
Right. So these two that we're going to be voting on, it is to set that system up
Yes.
so that we can start down a path that is correct and
Right.
legal.
Now, if the board were to decide to use to continue to allow the private tax buyers, there would still be auctions. It would be a different process and the costs, in our opinion, would increase because the interest rate, as the speaker indicated, as Mr. Butler indicated, or Member Butler indicated, the interest rates are different. They're higher. They could be higher. Tax buyers can get up to 18%. The county's limited to 9%.
So in my personal opinion, this plan that you're suggesting is better for the homeowner who's losing their home than the other option.
Yes.
So, thank you.
Thank you. Member Butler?
Okay, so I just to be clear, when you say we're going to acquire all tax certificates, what is the responsibility involved from the county? Is that that we are responsible for those tax burdens until we take it to auction? And then once we auction it for to cover all the costs. So at the very least, we get back what we were responsible for, but possibly there could be a surplus if there's a bid on it. Is that what's happening here?
Well, that's the hope, is that when we have these auctions that people, if it's a home or something that, there's going to be a competitive auction and people are going to want to bid on it to acquire it. So then there's a competitive bidding process and, the highest winning bid gets the property.
So in your experience, you're saying that there's very little risk of those properties not selling and that we would have to be responsible for it.
Could there be retention ponds and, there's a lot of, sometimes properties, let's step back a little bit and let's talk about the properties we're talking about here. Some of these properties, that are being sold are abandoned and they're not being maintained. And the windows are broken out, or there's been a fire and it's substantially destroyed. That's why it's kind of hard in some situations to talk about what the fair market value is and so forth, because, in some of these situations, the property is deteriorated or it's not maintained. And, the municipality's got to come in and cut weeds and stuff like that. They tack on costs if they do those sorts of things. And so there's a lot of moving parts to this. But in essence, the object of all the properties going to competitive auction is to try to get as much money we can for the properties to return the equity to the prior homeowners.
And again, I just want to be very clear. What is the risk of liability to us? Is it very minimal? Do we have how much would it cost the county, which is the taxpayers? So we might save, if it was a program where we would lose money on it, of course, all the taxpayers in the county would end up paying for that. But if it works well, then the individual homeowners, they get more money, equity back from their house, and it's a good thing. I'm just trying to figure out, what is that ratio?
We're essentially would take over we would do what the tax buyers currently do, or what the county tax agent typically does when they take title to a property now, and they're already doing it, except they're just doing it on properties that the tax buyers didn't bid on. And that might be a smaller home or something that's not a lot of value that the tax buyer doesn't think that they can make money on. Those properties are going to the trustee. So and the trustee we don't have any risk there, because any cost, if we have to maintain something or that gets tacked on to the minimum bid that we are going to get at an auction. So I would say the risk of doing the county being the trustee is little to none.
Okay, so there's like a 1% chance that you could lose money. I mean, is that what we're saying?
I don't even know, I mean, I don't know how we would lose money because any cost that we incur during the time that the property is being deemed, keep in mind that in many cases, the homeowners are continuing to stay in the property during the redemption period. We don't have title to these properties, well, because we don't, we own the tax certificates. We don't own the property. So the prior homeowner is typically still living in the home. And when a private tax buyer now, takes a tax deed, typically they got to get an order to have the sheriff go and evict the people and move the stuff out. That's typically what happens. So these properties, typically the homeowners are continuing to live in them. So, very little needs to be done if they're still there. We only own the tax certificate. We own the right at some point, if they do not redeem, to auction the property to the highest bidder. Does that make sense?
It's probably not likely, but can you say there's no liability to us?
You're never gonna get anybody here to say there's no liability for anything because I couldn't forecast that. But I'm saying right now, we are already doing this. The county tax agent has hundreds of properties that are already doing it. So I haven't seen any risk with the trustee in the 5 years I've been here. And so I would expect that track record to continue.
And is it fair to say that the trustee, I don't remember the name of the company, but
Joseph E. Meyer.
yeah, don't they represent like 95 counties out of the state of Illinois?
This is what they do. They administer these properties as trustee for various counties.
Yeah. All right, let's move on to Mr. Balich. Thank you for your patience.
I don't have a problem with what went on at the last meeting, the committee of the whole. I thought it was good. I researched this thing because I smelled something bad. And what I see is that the auction process, I didn't think that was a fair way to do it. So I researched Tyler and I went and read the whole damn thing. And I'll tell you right now, I found out that there's 3 processes that you can use to value property. One is the auction. That's the easiest one to do. And the one that pays the least amount of money usually to the people. Then there's the appraisal process and the equity lien process. So there's 3 ways we can legally do this under Tyler. Now, you've got to look at it as a person that's losing your house. You'd want to get paid fair market value for your house, to your equity. So if the county administers it, that's what would happen. So what you stated is correct. The county would administer it. But we would go out with a certified appraiser company and get it appraised. Then it goes up for sale, just like any other house would go up for sale. And then it gets sold. And it'll get sold at fair market value. So now if it doesn't sell in the first 3 months, then we lower the value by 10%. The appraiser was off. And then we keep lowering it till it's sold. The second it's sold, it's over with. Then the buyer gets a clean deed, not from the county, but from the actual owner. And the owner turns around and gets all of his equity. So the appraisal value way of doing it is the best. Then what I thought about was I wrote something and I put it on everybody's desk. You could see what my opinion was of a solution. But I think it's totally wrong to use the auction value because these companies that come in and buy it they're going to resell it. That's why they're buying it. So they're buying it at a low end. So we want to make sure that the proper equity goes to the homeowner. And the only way to do that is through using market value through an appraiser. So whether it be the county appraiser, that's probably not good because like you told me earlier, then it looks like we're prejudiced. So we would get an outside appraiser, but the system would work really well. There'd be no liability for the county. The county don't have to come up with any money. and it would be a clean sale. So, yeah, it's a little bit more difficult than the auction process, but you got to think of the taxpayer that's losing their house, and it could happen to anybody in this room. You could have a medical problem that bankrupts you. You could have something happen where you got hacked and you lost all your money. There's so many different things that could happen that this affects everybody. So it's not just people that are short money now. It could be somebody in this room in the future. So I look at it like this. Why can't we use the appraisal process instead of using the auction process? And I know I caught you off guard because I sent you an email to the wrong email, I guess. But I called you on the phone and told you, and you told me, yeah, you can use the appraisal process. So that's what I'm asking to go forward with, that we use the appraisal process to value these properties so that the buyer can make money or move into a house free and clear. And there's no problem. And the owner that sells it gets all of their equity, all of it. And I think that's the most important feature of the appraisal process.
The only issue that I see is if the professional appraiser comes in and sets an appraisal and then nobody buys it. So then the person that lost their home gets zero equity, right? Because it's
No.
appraised too high.
No,
No?
that isn't how we make the policy. So we say 3 months. If it doesn't sell in 3 months, that means the professional appraiser didn't appraise it right. So we lower the price 10%.
Okay.
And then if it don't appraise for 3 more months, we lower it another 10%.
All right.
But I doubt if the appraiser would be that far off.
So, and we did have a discussion and see the discussion, we're kind of talking about what the measure of damages is when somebody loses their house at a tax sale. So the question is how do we measure how much equity a person lost? Now, we don't really have any discretion over how this property gets administered because the property tax code tells us how we're going to do it. And the property tax code says auction. These things are to be auctioned within 120 days after the redemption period expires. There is no, we're not allowed to become the real estate agent. I read your proposal. The problem is that, you know, if we hire an appraiser, it says one thing, then the former homeowner is going to go out and hire another appraiser and they're going to top what we did. And then there's going to be a contest of what the equity was. And then the question becomes, appraisals can be very subjective because the condition of the core contents in the house, the water heater, how old's the roof, you know, this and that. Then, you know, you're going to spend a lot of time arguing over what should or shouldn't be the price of the property, where the auction, which is what the market is for this property, which is now the procedure set forth in the property tax code. I don't think there's really any discretion in terms of how the county can dispose of these properties. If, in fact, the county trustee, there's a very strict notice and sale provision provided in the tax code of how these properties are supposed to be done. And I appreciate the proposal you put out because we did talk about, how do we measure the loss of the equity? If the county board decided that, well, if the auction, we can, if there's an appraisal, we can go above the auction price, we'll pay more. That's like I told you on the phone, I suppose if the county wanted to pay more money, that can be a policy position of the board. But that's, we're talking about taxpayer money there, and to get into a situation where the appraisals and they're battling, it seems very subjective to me.
Scott, I don't want to interrupt you, but there will be none because we create the policy, and in our policy will state that the sale is going to be handled by the county and that there's no appraisals accepted by the buyer, and that whatever the county appraiser comes up with, that's the answer. period. Now, they can't do that. And then the other thing is if someone does it this auction way, right? And they get really aggravated because they think they're getting screwed. What's to prevent them to go to court? And because the federal government's going to trump the state, if you go to court, would you want to go to court and battle what the Supreme Court of the United States said? Because Illinois court said, no, we're going to go with you guys. You know they're going to lose. So the whole idea is that we should be following Tyler all the way. And we should also have to consider the importance of making sure the equity goes to the people that are losing their house. They're already in trouble. They're losing their house. Why should we make it so they get less money? And the county makes it easier to do by an auction. To me, that's immoral. And I don't want to see that happen. So that's why I'm pointing this out, that if we do the appraisal process, yes, there's going to be things we have to put in our policy, and we're going to have to follow the policy. But you know what? That's not that hard. Like I just said, you said a whole bunch of stuff about double appraisers and all this other stuff. We just make it in our policy that it's not accepted. The county gets an appraiser and that's it. It's all over with. So there's going to be other stuff that comes up, and that's got to be entered into our policy. And we can change our policy going forward if we find something wrong or something would work better. So I think that we should just really analyze the valuation and use something with the appraisal process, which goes along 100% with Tyler. And, you know, if anything that happens, people are going to sue all the time. But if we're following Tyler, we're not going to lose.
So what I understand is you are not in favor of this policy that's brought forward by the state's attorney, and you would like to go a different direction in the sale, correct?
I'm a part of it. The part that, you know, when they're asking for the $20 for the stuff that happened in the past, I don't have a problem with that.
Right.
When the part that says that they would like to be the administrator, well, the county's going to have to administrate this stuff.
You just don't like the auction style, you like the
saying-
appraisal.
I'm saying that
Correct.
our policy should be that we use the appraisal
Understood.
process.
Yep.
Instead of the auction process, which screws the people that lost their house.
Point
And-
taken, Steve. Yeah, we get
And I
it.
think that's important for everyone in this room to realize.
Mr. Brophy, could you make a few points and then briefly describe how the tax sale is
Sure.
taking place, please?
So first of all, let's define equity. How much equity is in your home today, Steve? You don't know. The equity in a home is what someone will pay for it minus what you owe. And what you owe, whether you're sick or it's been stolen or you're just didn't want to pay your taxes, what you owe is a clear number. Those taxes that haven't been paid is what you owe. So what someone will pay for your home minus what you owe today is equity.
Correct.
Okay? The best way to find out then what someone will pay for the home is to make it publicly available to buyers. And the reason why we're suggesting the route we are is that you want to do it as quickly as possible. Your as trustee, your tax agent, Joseph E. Meyer, will do that quickly because it behooves you and the prior homeowner. If you go the taxpayer route, they're going to try to draw things out because they're earning 18% a year. And the longer this thing goes, the more interest they make. Because no matter what, taxes and interest are paid first when that house is eventually sold. So let's be clear. Equity is not a fixed figure. There's nothing out there that says you're entitled to this much. Kelly, when you sell your home, it's what a buyer will pay minus what you owe. Everybody is treated the same. What the flaw in your argument, Mr. Balich, is that what one individual's opinion of that house doesn't matter. You're going to take more time, which costs the original homeowner, and who's going to pay for the appraisal? the original homeowner. It's going to be added to the amount he owes.
You're correct.
So now you're costing your homeowner that you're worried about more money in an appraisal fee and in interest in more time.
You're
That's the
correct.
flaw with your argument.
You're correct,
Now-
except there's one thing different. When I'm saying you put it at fair market value,
Whose opinion of fair market
And-
value?
the appraiser that would appraise it, and if we want, we can have
His,
three.
that appraisal
we
does
could
not
have
set
three
fair
of-
market
we could
value.
have- We could have three, they look at, an appraiser looks at the price that the houses in that neighborhood.
I
are
understand
selling
what an
for,
appraisal
and
does. I
then
think everybody here does too.
We could even say, all right, it's going to be 5% less than.
Fair
than
market
what the
value
price says. We
is-
could make a policy that says it's 5% less. We could do whatever we want.
Yes,
But the
and it
idea
still
is-
won't
Okay,
The
influence
idea
what
all
a
right.
is
buyer
get
will
the
pay.
very most money you can for the individual
Folks,
that's losing the.
That's a nice goal.
This is
It's
a,
not
excuse
until
me,
put an
excuse me, this is not a debate. Let's,
Okay.
please.
So now your options are with the new Illinois law, which is statute, we can't go back to the old way. You have two options. Do you want the county tax agent to auction these houses for you? Or do you want to let individual independent buyers do it? That's the question. What we propose saves you money and it saves the original homeowner money. It may return to them more equity.
I'm not talking about individual taxpayers. I'm saying the county would be the one responsible to put it up. For
That's
sale.
our proposal.
Yeah,
That's
but
the only thing
using
questioned
the
today.
Fair market value, not
Steve-
the auction value.
All right, do you have anything else to add, Mr.
Fair
Brophy?
market value is set by a sale, what a buyer will pay. That's what fair market value is.
All right, I see no other lights. We're going to take this to a vote. Resolution 26-5311. We did have a motion and a second. Can I have a roll, please?
Richmond. Williams. Butler.
Yes.
Freeman. Hickey. Newquist. Oxley. Pretzel. Trinier. Winfrey. Van Dyne.
Yes.
Motion carries.
Thank you. Resolution 26-5312, a resolution authorizing the creation of the equity fund fee for the county treasurer. Moved by Winfrey, seconded by Freeman. Previous by Trinier, seconded by Oxley. All those in favor, please say aye. Aye. Anyone opposed? And motion carries. Now, Resolution 26-5095, ad hoc ordinance review minutes. It's the final meeting that we had on June 9th. Motion by Trinier, second by Freeman. Previous Hickey, second by Winfrey. All those in favor, please say aye. Aye. Anyone opposed? Motion carries. Number 5 under new business, 26-5196, authorizing the county executive to execute an IGA with the Village of Hazel Crest to provide access to our countywide radio system. I'm sorry, did I jump? Oh, I apologize. Okay, so we'll continue with Hazel Crest. Was there a motion? Perfect. All those in favor, please say aye. Aye. Anyone opposed? Motion carries. Jack, jump back to 4, sorry. 26-5195, authorizing the county executive to execute an IGA agreement with the Village of Monee to provide access. All those in favor, please say aye. Anyone opposed? That motion carries. 26-5197, authorizing the county executive to execute an IGA with the Village of South Holland. Second Trinier, previous by Winfrey, seconded by Hickey. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. 26-5221, raffle license bond waiver for United Way. We have a first and a second. There's a question by member Trinier.
Can somebody elaborate on why we're giving them the waiver? Because I always thought of that as, something that you do for a not-for-profit organization, like we've done it for the Will County Bee, because they can't afford it. I have the funniest sneaking suspicion that ExxonMobil could probably buy me. So paying for that bond waiver is nothing. And I don't know anything about the Green Garden Country Club, but I'm assuming they're a for-profit entity. I'm just wondering why we're even considering this.
Thank you. We have Ally Harms with the executive's office to explain.
Member Trenier, both of these are for United Way. One is at Green Garden, one's at ExxonMobil. Yeah.
Mr. Butler, do you have a
No, I
question?
just said, it was right before Green Garden, United Way.
Okay. All right, so we have a first and second. Previous? Or do you want to roll? Previous by Butler, seconded by Oxley. All those in favor, say aye. Aye. Anyone opposed? Motion carries. 26-5222 raffle license bond waiver for United Way. Moved by Oxley, seconded by Trenier. Previous Newquist, seconded by Winfrey. All those in favor, please say aye. Aye. Anyone opposed? Motion carries. No other new business that I know of. New business. Member Freeman.
Yes, I'm sorry. I have a question regarding new business. Since we have just approved the minutes for the ad hoc ordinance, do we also need to dissolve that committee?
It's something to consider. I think it comes to executive committee.
It would come to executive committee. We can present a resolution for discussion next month with regard to the dissolution of that
Yeah, I
ad
think
hoc
we
committee.
should dissolve it with something in there about and reevaluate any ordinance changes on a regular basis so we don't have to spend 4 years. Thank you.
Member Trenier.
Yeah, that would be my concern. I know that we discussed in the committee with Mr. Mock, our staff member from the State's Attorney's Office, that going forward, should we make any changes in the executive committee or any committee that deals with an ordinance, that they would automatically update it in the official ordinance record. But I would agree with Member Freeman that we need to have something, and I don't even know what it is, maybe another resolution or a policy that says on these dates, we will review the ordinance, the whole thing in a, all over again so that we don't, or maybe that committee takes on one chapter a year. I don't know. We need to have a plan. Dissolving it, if that's the answer, fine. But we need to have a plan on how we're going to move forward so 40 years doesn't elapse again.
All right, I suggest give me some suggestions on what maybe the board would like to see, and then we can bring it back for discussion.
Yeah, because
Okay.
again, I'm not sure. And maybe the executive committee can handle it and they do one chapter a year, but
I would suggest that.
something. Okay.
All right.
So,
Yeah, Mr. Butler.
yeah, I think what we said it was when the board made rules that it should be transferred, like every time the board created a rule change, that it would automatically be transferred to ordinances. So that only happens once every
2 years.
2 years.
Yeah.
Yeah, right.
Okay. All right. No other new business? No request for state's attorney's opinion? What, new business? Yeah, you still have an opportunity. We're going to get through the rest of this first. Yeah. Okay, committee reports. I'll start with land use and development. Mr. Pretzel.
Nice,
Thank you.
nice uneventful meeting. Nothing to report. Read your agenda, but should be a nice, quick portion of the agenda.
All right, thank you. I think we all thank you. Finance. Mr. Pelkey.
Land use has put in, Chair Pretzel, land use has put into a copy of the rules or the ordinance revisions with regard to solar. So a hard copy that's redlined should be in your mailboxes, correct, Jackie? Okay, we have copies of the ordinance changes that are available to distribute with regard to those text changes on the solar farms.
For anyone who doesn't have a copy.
We can get those
they
today. For
provide
anyone who
those.
doesn't have them, we'll get them to you today. And then, and they'll be in the mailboxes for everyone else, this week. So.
Thank you. I did forget to mention too, because it wasn't done, it didn't go through committee, but that Badger case is coming back.
It's coming back.
So, you know, that'll be on the full board agenda as well. So that's the one in Homer Glen.
Thank you. Now, Chair Newquist, Finance.
Finance, nothing. I mean, everything, I believe was approved and shouldn't be any issues.
Thank you. Public Works and Transportation, Chair Trunier.
Yes, if you could, please save space for an additional IGA. It will be for Wilmington. They did submit new policies. So we need to save a space for that. We had a couple of them that did not pass out of committee. Those will still be on the agenda, correct? I just want to make sure everybody knows.
Yes, the
there's
ones,
still-
yeah, it'll all be out
Yeah,
for
they'll all
vote.
be there.
Yes.
But we'll have some, well, did we, I'm trying to remember if we were
I-
unanimous.
I may have misspoke.
Everything that the committee passed will be on the county board agenda
Uh-huh.
for this month. And if you choose to save a space for the city of
Wilmington.
Wilmington, that will be on the
Mhm.
agenda as well. For any other agency that has yet to submit a policy that the committee has established, is kind of the benchmark that they're looking for. They can always be placed back on the Public Works Committee, you know, to restart the process.
Right. So I think there were two that we did not pass out of committee. Those will not appear.
Those will not appear on the
I
county.
just want to make sure, because I know in some parts of our job, even if we don't pass it, land use in particular, if we don't pass it in committee, it still comes to the full board. So I just wanted to make sure everybody was aware of what was going to happen with those two. Yeah.
Okay. Regarding Public Works and Transportation, Member
Yes.
Dickey?
Thank you. I appreciate the opportunity to just chime in here for a sec. The two that were not passed were Wilmington, and that was my error. The police chief there had sent that to me, and I just assumed that it had been folded into all of them that we were reviewing. And then the other one is City of Joliet, and my understanding is they've been unresponsive. So those are the two. So if we save space for Wilmington, then I think we're down to one. Is that correct?
In fairness to Joliet, they've responded. They just haven't yet submitted a policy that is in line with the Mokina policy that the committee was looking for.
That's kind of unresponsive, is it?
They responded and they said they were going to look at it and they were going to submit.
All right,
And
thank you.
I
for the
might as
distinction.
well, I might as well give you a preview of coming attractions. I have spoken with the state's attorney. We're going to ask for some modification in the language. We're going to do it as a motion to amend. And we're going to ask that how do I phrase this? That any IGA that gets signed and is agreed to, if we make an ordinance change here at the county, that those communities would have 30 days to decide if they wanted to comply with our new ordinance, or if they wish to opt out of the intergovernmental agreement, because we are wanting them to meet a standard. And just because we don't have that ordinance yet, we can't tell them exactly what it is. We've just been using this example of the Mokina policy. So we want to give them that opportunity, that if they don't want to comply with this future ordinance, they can remove their cameras and opt out within 30 days after our change, and/or they will comply with whatever the changes that are made will be. And that'll be what the amendment's going to stay. And the lawyer's going to write it up in nice legal language for us so that we can discuss it at the full board, which I hate to do, but I think this is really important with all the changes in AI that are every single day. We need to protect ourselves.
Anticipate this for full board next week?
Yes.
Thank you. Member Ogala?
Thank you. I don't think 30 days is sufficient. Because if we make a change, the community may not, they may have met the last week. They're not going to meet for an entire week, an entire month, or two, or I think we need to give them more than 30 days. That's just, I don't think there's enough time. I think you need to make a 60, 90 days, something like that. It takes time to have a conversation.
So the conversation is that Chair Trenier is going to let the state's attorneys know that maybe a longer time period might be necessary. Thank you.
Yeah, thank you.
Okay, does that complete your report, Member Chair Trenier? Thank you. Member Butler is Public Health and Safety.
Nothing to move forward, but I did want to just make one comment during Forest Preserve today. I had told a story about a pond. And I just want to let everyone know that at my public health and safety meeting, it was the health department that informed us on what happened at the aquifer. All I knew was I drove by the pond in the morning, it was there. And when I drove back after work, it was gone. But I guess it was down for a couple weeks. And that was because the health department had to make sure that it was safe, and then they had to chlorinate and decontaminate the water. So just keeping it fresh about the wetlands and the importance of, having them.
Thank you. Legislative Chair is Member Winfrey.
Thank you, Mr. Speaker. The Legislative Committee continues to work on the state and federal agendas. If there are comments or questions or additions to the agenda, they still need to be sent over to the Chief of Staff so that we can get those in and wrap that up. We don't have anything else special to bring forward. We have one resolution for Thursday, which I don't think should be an issue.
Thank you. Capital Improvements and IT, Chair Freeman.
I have nothing to bring forward.
Thank you. I'm going to skip over landfill, Mr. Oxley, because I know he wants to brag about our big savings or our revenue that we made. No, I'm kidding.
Kick you to the curb. I mean, really,
Chair Oxley, go ahead.
Thank you, Mr. Speaker. Good news from landfill. We have the compressor ordered that was originally taken out of the budget. We're going out for requests for qualifications for someone to install it. The engineering is being worked on. They're almost done with that. And for the first time in many months or years, it's showing $400,000 in the black. So we're moving forward. Thank you.
Thank you. Great news. Nothing to report at executive. We've heard it all already today. No appointments by the county executive at this meeting. No announcements or reports by the chair at this time. No need for executive session. So this approval of the Will County Board draft agenda might be lengthy, so bear with me. 26-5288 Will County Board draft agenda. Can I get a motion to put it on the floor? Motion Hickey, seconded by Trenier. I'll need a motion to amend the county board. I'm sorry, that should come at the end. Motion to amend the county board agenda to add all items approved by the executive committee today. Motion Trenier, seconded by Winfrey. There are further amendments coming, so I'm not going to skip over that. Yeah. Previous roll for previous Hickey, seconded by Newquist. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. And then there's two items that we're asking to save space, three items now. I'll start with the easy one. A motion to save space for a resolution authorizing the IGA agreement between the city of Wilmington and the county of Will for placement of automatic license plate reading cameras on the county highway. Motion Trenier, second Hickey. Previous Newquist, second Freeman. All those in favor, please say aye. Aye. Anyone opposed? Motion carries. All right. At this time, the circuit clerk had some a new revelation as of late. So we have Chuck from the circuit clerk to explain this item. Okay, gentlemen, would you like to come up here at the podium? Looking for a motion to save space on the county board agenda for item 26-5322, amending 37-05 civil fees to be charged by the clerk of the circuit court consistent with amendments to 705 ILCS 105/27-1B Clerks of the Courts Act through Public Act 104-0468. Can I get a motion? Motion Newquist, seconded by Winfrey. We will continue that discussion. Gentlemen, go ahead and explain what we're looking at here,
Thank you,
please.
Mr. Speaker. Thank you, members of the committee. We just learned from the AOIC, the Administrative Office of Illinois Courts, that the governor signed a piece of legislation that added fees to various schedules, specifically for filing fees and appearance fees in civil matters. The gist of it is, previously there was a $100 fee that was assessed in probate matters for purposes of the guardianship and advocacy fund. That particular statutory provision has now been repealed. And what the legislature has done is now taken that fee and appropriated it to the Circuit Clerks Act and the various schedules for filing fees. So what the legislature did, instead of taking $100 or assessing a $100 fee in all probate filings, what they have now done is enacted a piece of legislation where $5 additional is tacked on to a civil filing fee for filing a lawsuit, whatever the situation may be, a petition, and also a $5 fee in appearance fees amongst the various schedules. Specifically for appearance fees, or the schedules that are affected for the appearance fees, I believe are 1 and 3, and for filing fees, I believe it is schedules 1 and 3. And why this matters is because the county board has adopted the statutory fee breakdown that was passed by the legislature, and they have adopted it and implemented it within the county ordinances. So to mirror the state statute, we have provided a proposed amendment to the county ordinance, which specifically is County Ordinance 37.05 civil fees.
All right, questions? Member Trenier.
Yes. Are we going to get a copy of the actual fee schedule that you're proposing? Will that be attached to our board agenda?
That'd be a question for Mr. Pelkey.
It will be. They sent over
Red line?
a draft resolution yesterday. We'll send it out. It'll be attached to the county board agenda, and we'll send it out to you
Okay.
as well, to the county board members.
And then do we need, will it be redlined? And then do we need also on that same agenda then to approve an update to the ordinance? Or is it merely voting on this, we'll change it? And again, I know that it's hosted by the county clerk, I think, on her website somewhere. And then I don't even know if that company, American Publishing, has actually finished their work yet. I don't know. So just kind of wondering how all the rest of it will fit together.
I know the ordinances will be updated to reflect this. I don't know what the official process is for that, but we'll get an answer
Yeah.
to that question for you by the time you're ready to vote for it. Yeah. And the resolution is not redlined, but it is in bold. The changes are in bold on that, so.
Okay, thank you.
Unless you prefer it in italics or something.
I believe I have it in italics,
Do you?
underlined, and bold.
Okay.
All three of them.
All right. Other questions, Member Ogala? Oh, okay. Thank you. We ready to vote? We do have a clean vote. We have a clean roll. Previous, Trenier, seconded Hickey. All those in favor, please say aye. Aye. Anyone opposed? That motion carries. Thank you very much, gentlemen. We'll see how it pans out next week. Thank you. Okay. Now, Mr. Butler, we did, I think everybody on the committee, or maybe everyone here today, received a copy of your resolution with no number on it, which is fine. Now is your chance to go ahead and explain, or, give your pitch and ask for a motion to save space when you're finished. There you are, sir.
All right, thank you. First of all, I just want to explain on the end of page 2, obviously, you can get rid of 4 because that was if I was doing a special, requesting a special meeting. So I apologize for that. And then, of course, the third page is just my list of agencies that I was trying to, that's not part of the resolution, but it's a list of agencies that I was trying to contact to do my own investigation. The premise of this is that in 1845, they passed laws that allowed us to basically drain the wetlands. And we've lost 90% of our wetlands in Illinois. And we can see through repeated times from these different agencies that come in talking about the aquifers drying up, it has a lot to do with the fact that we've lost all these wetlands. And I understand it was for a worthy cause for farming to feed America. But if we are no longer using those lands, they are supposed to revert back. I have tried very hard to try to find the exact laws and go back, but I'm just not qualified to get that. I'm asking the state's attorney to get in there and figure this out. There's wetlands that have to be preserved, and it's their job to protect those lands. And I'm just asking them to investigate and make sure that any wetlands that are already there are not damaged, and that wetlands that are farmed wetlands that aren't really being treated as wetlands, that they are. I know, and in Tuscany Hills, there was a project that happened a few years back, and they got the permit to do the project. It wasn't until the residents came back and proved that these farm wetlands were actually wetlands that they stopped it. So, and I get it, the laws were made 150 years ago, but it will harm the local properties. I mean, the surrounding properties. They're going to suffer for it eventually. In Green Garden, it's very evident. They got massive flooding that just goes all different places. There's no control. There used to be wetlands out there that the water would just kind of get slowed down and held into. And right now with this project coming in, 9,000 acres, there's no way to tell how this is going to play out. So all I'm saying is I want to save as many of the wetlands as we possibly can, even if it's a 5-acre wetland here, a 5-acre wetland, it doesn't matter, because those 5 acres are going to produce 1 million gallons of water that are going to go into the aquifer. And it's going to slow down flood water that's going to go into surrounding properties. So, we can't just let this be forgotten and just let the law be ignored. Someone has to investigate it. I've tried. It's very difficult. I just know the laws were put in place, and I can't find anywhere where it says, we don't enforce those laws anymore. So that's what I'm asking the state's attorney to do.
Okay, thank you. I will go to Member Hickey first.
I think that what Member Butler is talking about is really, really important. I do ask, I guess, what we choose to do as a county is important as well, but there is, I believe, some legislation that has just come through by Senator Ellman. I believe it was signed into law. I was double checking this, and I can't say that I trust what I'm getting as a result here, but she introduced the Wetlands Protection Act this session, and it is talking about the local loss and actually doing something about it. It's oversight program safeguarding vulnerable waterways and wetlands. So
right, and that's the key right there. Is like a lot of wetlands that are by waterways, watersheds, creeks, or whatever. Those are definitely federally protected and protected by the state. But if they're not recognized as wetlands, because a lot of these farmed wetlands, which obviously, they're not even really recognized as wetlands. And most people, if you walked by them, couldn't tell it's a wetland because they've been drained for 100 years, But if they're not going to use them for farming, they should be put back to wetland, And we had people come in here, and part of it is you have to leave the fields fallow for a year. You can't just keep spraying insecticides or herbicides on it and expect the plants to grow that are supposed to grow there. Okay. And if you continuously drain them, of course, they're not going to accumulate water, So we just need to get to the bottom of it. And I feel like Will County, we should be looking into this and at least get it straight from our own legal department, what the laws are and then make sure they're being followed.
Thank you. Member Trenier?
Interesting topic. I'm definitely interested in reaching out to Senator Ellman's office to find out exactly what that bill will do. My concern, I guess, would be if this farmland is now being leased for some other purpose, a solar facility, and we tell them they have to take out the drain tiles. If it's leased, that land is going to potentially, after 30 years, go back to farm. It would be the same thing even if the solar company owns the land. It's potentially after 30 years, it could become some other kind of energy thing, or it could go back to farm. So I'm not sure that I'm okay with the idea of pulling out drain tiles that have been there for 100 years. I do understand, that the water's got to go somewhere. And if we're not growing corn there, maybe there will just automatically, it'll just turn back into wetland, even with the drainage tiles. I don't know. I'm not a hydro engineer. And I do know they are going to plant native plants on the property, but again, they probably don't use as much water as, say, a ear of corn or a soybean. So I don't have enough information. I'm not sure that our state's attorney's office is going to have this information. I would be more inclined for us to do our homework and speak with our legislators and also talk with people like the Illinois Department of Natural Resources and or other organizations that are protecting the water. I don't know that the state's attorney is going to be able to give us a good answer. That would be my thought. So.
Thank you. Member Newquist.
Thank you. I appreciate the motivation, that goes into this, but I do have a couple of questions. One is, right, the Army Corps of Engineers, as I understand it, doesn't really recognize these farmed wetlands. People know they exist, but if you look at a map of wetlands in the state of Illinois, these farmed wetlands aren't going to appear on them. So my first question is, how do we even identify these areas? You would have to know specifically where drainage tiles are, and correct me if I'm wrong, but there's no comprehensive map of drainage tiles in the county. That's my understanding. So that would be one hurdle. And then the other thing, are you suggesting that solar fields or solar developments could not be constructed on a farmed wetland?
Well, they would tell you that they're not any solar panels are being put on farm wetlands because no, they cannot. But they will still have the land. And it may not be that a solar panel's on it, but it is going to be not farmed. So those parts of that, whatever the property that they're not using for panels would have to be restored, I would assume. And I agree. I don't know if the state's attorney can do it. And that makes me sad to think that they can't, because it is their responsibility to investigate this sort of thing if there is any kind of endangerment to the environment. So I hope that they can. Did I answer your questions, or was there?
You did. My comment though about mapping the drainage tiles and the farm wetland still stands. It seems to me this has come up previously, and the cost to doing that would be enormous. So that's my only comment on that.
So the Forest Preserve, said that they can map them. I've talked to them, and I'm not asking the state's attorney to map all the farmed wetlands or to map all. I'm just trying to get to the bottom of, let everybody know, like, hey, if this was a wetland and you're not using it, you're supposed to let it return back to a wetland. And it seems like, that has not been stated. And I want the state's attorney to do their job and get out there and find out the facts on that and to make that statement if it is in fact, enforceable.
All right. Leader Richmond, you good? Okay. Mr. Oxley?
Thank you, Mr. Speaker. I think the proper department, Dan, would be the land use and engineering to handle this. We have a GIS system with the county that identifies wetlands, the elevations, everything else, as the Army Corps of Engineer does. There's companies out there, when you develop property, there's companies out there and it's required by codes that you must identify the field tiles. So that's easily done. I'm not an expert at it, but I do know the process for it. So we have the capability. I think the proper place would be land use and engineering to handle that with a backup from the state's attorney about what the law is and what isn't.
Well, this primarily deals with the law and the responsibility, what's supposed to happen with the land. Obviously, I'm not asking the state's attorney to, find the tiles and stuff and that. But there just has to be a framework how this stuff has to be handled. And once the state's attorney, clarifies that, then we can go to land use and other agencies to try to identify these wetlands. But I don't expect the state's attorney to do that.
Understood. Thank you. Member Ogala?
Thank you. So in hearing what Dan is saying here, it makes sense because the solar companies cannot put solar panels in a wetland, okay? So back in the day when the farmers came and they put field tile in, they took a lot of the wetlands out. So to identify a wetland, you have to have certain species and types of plants need to be growing. Well, you won't see that in a farm wetland because the tile's there, so it's eliminated the wetland, right? So the suggestion is that you leave it there for length of time to determine if it goes back to a wetland is what would make sense, because that would give nature the time to go back and create the wetland if it existed there. And if not, after that time, they could go ahead and do it. So I understand what he's saying on this with the wetlands, because they can't put it, they have to avoid wetlands when they're putting in their solar panels, right? So that's great that we do that. We also have ag protection, and the Illinois legislature doesn't care about farmland protection because they've passed laws that say you can put non-farm uses on agricultural land. So maybe this would be a step that would say, hey, at least we could protect the areas of the farm parcels where there was a farm wetland in existence, and that they would not be able to put solar there. Because I don't know how many of you drive past solar facilities on your way in. I go through quite a few that are all in the building process, and they do a lot of earth moving, which they say they shouldn't do earth moving. They put in a ton of stone. They've put in field tiles and pipes in the middle of somewhere thinking they're going to get something done, because they have developers that don't understand. They don't understand the flow of water and drainage of water. And I know the Soil and Water District has been very actively involved in many that are going on out in Eastern Will County. One on Eagle Lake Road, and also now on Will Center. That piece of property was never really flooded. And that right now with all the rains, there's a lot of flooding. So I'm thinking the tiles got disrupted, and I think that would be a wetland. I mean, that one parcel I think would be a wetland. It is so wet right now. It's really underwater. So I think what Dan is putting forward here is a good idea. It's something to look at and protect the environment for the future.
Thank you. Well, I'll be honest. Sitting up here, I don't have a chance to read all this. So I am willing to vote to move it forward to the full county board. That's the minimum I can tell you. I do need to be able to read this. So I will be willing to save space.
Bill,
would you go ahead with your motion then?
Yeah, I would like to make the motion that we add this to the county board meeting.
Second.
This
I
resolution.
have a first by Mr. Butler, a second by Mr. Oxley. Discussion. Member Newquist?
I just want to say that I'm not opposed to this, but I just don't think we have enough information. I really think that we need, before we even vote on a resolution, I mean, this resolution seems to be a lot more complicated than just asking the state's attorney's office to move forward. I mean, I think we need like some kind of, I hate to say a study. I don't know if it's a formal study, but I mean, I think that the the point definitely should be investigated, but I'm not sure what this resolution is going to accomplish. I'd rather see us have some sort of, direct somebody to do some research into this and investigate it as a first step before going forward with the resolution. That would be my comment. Not that I'm opposed to investigating this. Thank you.
Thank you. Any other comments, Mr. Butler?
Just wanted to clarify, we're asking for legal clarification by the state's attorney. We're asking them to investigate and into, let's see where I say it. So we're asking to investigate the concept that you have farmed wetlands, that if they are no longer being used, that they need to be brought to their original state. And somebody's got to follow that track of law and identify that for us.
I see Ms. Hammer come up.
So your resolution states, urges the Will County State's Attorney to promptly investigate. One, the State's Attorney's Office isn't an investigative body by definition. However, we do give legal opinions. However, the next portion says, any allegation, evidence of improper non-agricultural use of such lands. Who's determining that? I understand your exact point of the wetlands and preserving. I don't understand what's directing us to do, but also the Illinois EPA Act, which you've cited, in that statute, they determine the agency when they're doing violations that they only involve us when they believe that it cannot be prosecuted without the state's attorney's office or other local of unit government. I just got this obviously today and we need to read. So that's just a broad overview of that.
Soil and Water said that they thought there was like 13 acres that were included in this of wetlands, farmed wetlands. So that was in that report. And then there was a report of the short-eared owl, but it wasn't reported in the permit to the proper authority.
Are you talking specifically about one project or another?
I'm talking about the solar project that's going through now in Manhattan, that part, the short-eared.
The larger Earthrise one?
Yeah.
Okay.
So these things that is a possible, that gives you the power to investigate that, because that is something that, for, the environment, if there's a danger to the environment for those animals and their habitat, then that does give the state's attorney not only the power, but, the duty to investigate that. So
when you cited the statute, 31.1, can you please point that out to me, where you find that in the statute?
You mean?
And we can have a conversation
Yeah, I don't
via
have
email or
all
other.
that stuff in front of me, but I can, yeah.
Yeah, because I pulled up the statute
And
as well.
okay, well, and I talked, obviously to some lawyers and stuff like that, and they said I was right in bringing that up, so.
Okay, Member Trenier?
I understand where Mr. Butler wants to go. I don't disagree with him at all. I just think the approach is incorrect. I would really advise, going to your state legislators and/or Senate Member Elman, who's already put forward a bill on this topic, and ask the questions. They will go to the legislative, I don't know, not JCAR, they're the rulemaking authority, but there isn't a body down there. Again, I don't serve down there. I don't know the name of it, but it's not the state's attorney. And they can tell you what laws are on the books and what would apply in this particular circumstance. They don't investigate. They just don't. I mean, if you wanted them to just see if they could figure out if there were any laws, well, sure, you can ask the state's attorney to do that. But I think a much better resource would be go to your legislator and have them talk to the people in Springfield to come up with a law that would impact these wetland, farmed or unfarmed wetlands. They've got to have some information. I mean, they make the laws.
Unless it's this environmental issue, then that does give the state's attorney the right to do that.
They can bring charges if they see there's a
can
violation.
investigate.
but somebody has to tell them what the violation is. They don't go looking. It's sort of like our land use department. They don't drive around Will County looking for violations. They don't. If somebody calls them and complains and says, this is a problem, then they can say, yes, that violates our ordinance. We'll go out there, take a look. We'll,
I mean,
fine them, whatever. But they don't go looking for it. And the state's attorney doesn't either. Somebody has to bring them.
Soil and water estimated 13 acres of farm wetlands were part of the
I
project.
don't disagree with you,
Well,
but
that's the
I'm
call.
saying
That's the
that
call.
the
That's
people
the
that
notification.
Okay.
tell you if it's a violation are the people that create the laws.
Two more comments, please. Member Freeman.
Thank you. I'm going to say I was with you, Speaker, when you said let's send it to the full board, but I'm hearing the questions. And before we take it to the full board, I do feel like it needs more discussion. And the state's attorney needs to look at it, I have a feeling, and kind of decide, give us their input. I'm not sure it's ready. I like the idea. I think that it is something that we should look into and see what we can do as a board. And I support and applaud Mr. Butler on this, but I do not want to take something to the full board that's just simply not ready yet. And I think that it's a good start, and I would hope that we can maybe postpone it until we have a chance to dig in and have a discussion on it and more information, and the state's attorneys had a chance to look into it as well.
Understood. Thank you. Member Newquist?
Yeah, I just want to say that determining things like endangered species and stuff, that should be part of land use's job before they issue a permit. I mean, if something like that was to be found. But Dan, I just want to clarify. So basically what you're saying is, so let's say Soil and Water has said that there's 13 acres of farm wetlands on this project. What you're basically saying is that there's not going to be solar panels on there anyway because they've been identified as farm wetlands. But what you're saying is they should be allowed to be returned, those 13 acres, regardless of how many solar panels there are on that project. Those 13 acres should be allowed to be returned to wetlands. But I don't know that.
That's correct.
Thank you. But I don't know, that's the other thing under the current law, the siting law, I don't know, the solar laws, I don't even know if we have the authority to dictate that. That's just another point I'm bringing up. Thank you.
Okay, thank you. So I see both sides of the issue here. Some may want to put it to full board, some may not. I said I would give you the opportunity, so let's take a roll, please. We are voting to save space on the full county board next week for this resolution that was passed out. Yes, ma'am.
And if you want, I'd be willing to, if the state's attorney wants to look at it and alter it a little to make it fit, I don't have a problem with that. If there's some things on it that need to be changed to make it, work.
So let me ask this then. Do you want to stay with your motion to save space, or would you want another crack at getting some more information before we take
I
it
don't
to
want to
vote?
miss this next board meeting, but
Okay.
if the state's attorney looks at it and makes a few amendments to it, I don't have a problem with it.
Well, it might be time constraint. I don't know what their schedule is, but
Well, it's not just that, just briefly looking at it, just like Member Trenier brought up about land use. We prosecute crimes, right? We don't go investigate crimes and look for crimes like the police do. The Illinois EPA Act regulates the agency, and they can bring us into an action when they feel the need. So I understand what you're trying to accomplish here, but it's very broad and ordering the state's attorney's office to investigate. So I may change everything on it and you won't agree with any of it.
Okay, then no, I would just like it as is.
all right. Roll call, please.
Richmond? Williams? Butler?
Yes.
Freeman? Hickey? Newquist? Oxley?
Yes.
Trinier? Winfrey? Van Dyne?
Yes.
It's a tie, 5-5.
5-5, motion fails. Now I'm looking for a motion to approve the county board agenda as amended. Motion, Trenier, seconded by Hickey. Roll call, please. Oh, all right. We do have a motion and a second to approve the county board agenda as amended. Questions on that, Mr. Richmond?
No, thanks, Joe. I wanted to bring something to your attention before. I know we've talked before about a potential resolution for the upcoming election regarding property taxes. The more that we're in this budget season, it's the time where, everybody's looking at their property tax bill. They've got to make this second payment. We just had some serious discussions today regarding people losing their houses regarding property tax. And we have a resolution in regards to property taxes, and we'd like to save space on the agenda for that.
Okay, well, can we rescind our motion to approve the county board agenda as amended? Who do we have? Do you want to rescind? Rescind her motion to approve the county board agenda as amended. I will say this, Mr. Richmond, I did receive your resolution. We've had conversations, and I know I've had conversations with Mrs. Ogala. This contains a resolution that would put a question on the November ballot to the constituents about property taxes. I also have received a request to put a referendum question on the ballot in November for a millionaire's tax. And what I had explained is, at this time, I don't feel that I want to go into the battle between the parties on two separate issues. I think this county needs to focus on the budget and doing the work that we actually can do here at the county. So I denied to put either resolution forward. And if you want to make that motion, Mr. Richmond, that would be great, but I cannot support that. So thank you.
I'd like to make that motion because all I hear from everybody is their property tax bill is so high. The fact that the state has taken away roughly 40% from the local government distributed fund, LGDF fund, over the course of time now. I mean, that's impacting all municipalities and all taxing bodies. And I think it's at some point in time, what we need to do is take our responsibility of representing our residents so they don't continue to lose their homes and or have these escalating property tax bills. So I'd like to see that motion.
Motion to save room for your resolution. All right, we do have a motion, seconded by Oxley. Discussion? Member Newquist?
Just a quick question. What does the resolution say? I have no clue.
I've got a copy here. I mean, I know I did share it with leadership and that, so.
Yeah, the question is whether you want to save space for, and you heard my comments, so if you guys are no comments at all, are ready to ask for, okay.
Yeah.
Roll call. Mr. Oxley, are you good?
What you've got to realize here, what he's saying is he just wants space for this resolution. I haven't seen it either, but I'm looking at Plainfield school districts. The state took, I believe it's $11 million from them and gave it to Chicago. Rockford, they took $8 million. Valley View and Romeoville, they took several $1 million from the school districts, gave that money to Chicago. Now we're looking at layoffs. In Valley View, I'm told up to 100. Plainfield, I was told at least 100, and I don't know the amount for Rockford. And I think what he's trying to do is protect everything here, and we're in a downhill battle here, and we got to pick it up.
All right. Member Hickey?
Thank you. I appreciate this and I too want to make sure that we are not overburdening our constituents with taxes. I haven't seen this. I don't even know what we're really talking about. And I'm sorry, I have heard this objection from my colleagues many times that we haven't had time to review this. So I can't vote for something that I haven't even seen or know what we're talking about. I just respectfully, I can't do that. So thank you.
Members of the committee, Mr. Butler?
So just reminding everybody, we're just voting for an opportunity to present it. We're not actually asking anyone to vote on it.
Correct. Save space for the full county board. Member Ogala?
Yeah, thank you. I mean, you guys just voted on a resolution for the clerk, the circuit clerk, and you didn't see that either. And this would just be a resolution advisory public question concerning property tax relief to the voters of Will County. It is, I think it's important for us to be a leader in this, to say that we realize that we have problems. We've had a committee of the whole and other conversations all regarding all the properties that are lost to tax sales. I don't know what percentage of them actually are a home that somebody owned, but they couldn't afford their property taxes. I haven't gotten a breakdown on that particular situation. But somehow we have to address this. We have the highest taxes in the country, one of among the highest property taxes in the entire country. Somebody has to take a step forward and say, hey, we realize it, and we're asking our state legislature to do it. The referendum question would be, should the Illinois General Assembly pass legislation that would cap and lower property taxes and would provide state funding to local governments that agree to reduce property tax levies? You could do that through the LGDF. Maybe they'll give us 100%, or the local library or whatever, if they cap their property taxes so that we could see some relief. We have to see some relief. They have to redo this code. And if nobody ever makes an effort to take the steps forward to bring it to the state's attention, I don't think you're ever going to get any changes. So I think it's something that's good. We have a copy here. If you guys want a copy, I suppose staff could make a copy here. I understand that people don't ever want to address this issue because they're like, well, how would we move forward and how do we continue to grow? We have to look at what is affordable. All I hear all the time from especially the Democratic caucus is the affordability. We need affordable housing. We need affordable this. You can't have any affordability then when there are people that are paying $1,000 or more for their property tax bill. And that goes to a lot of rental properties. So if you have high rents, the person who owns their property, whether it's a single family home or a multifamily home, if they're paying in excess of $1,000 a month, you can bet that who's going to rent there has to pay in excess because they have to collect from the renter the monies to pay their property taxes as well as maintenance fees and things like that. If we're ever going to reach affordability, somehow we have to start making a change. So this would be just to ask for that. You didn't see the resolution, like I said, for the circuit clerk's office. I understand it's a little bit of a difference in it, but I think it's important. I think it would send a message to our taxpayers here in Will County that we care, we hear them, and we're doing what we can to change that. Thank you.
Thank you. Member Freeman?
Thank you. Wow. I am not going to be able to vote for this. I think that I agree with Member Hickey. We haven't seen it. We haven't discussed it. It is an advisory. It is just letting the governor know what we think again. And I don't know if the state's attorney has looked at this. And I don't want to bring something to the full board that it's like the full board is not the committee. The full board is where the business gets concluded. And I don't want to send something forward that would, where we haven't done our job on this committee. So I thank you.
Thank you. Leader Williams?
Thank you. A couple of things. So this is capping property taxes at what? Where are they capped? Okay. Well, we don't have a set amount we want to cap that, is what you're saying. Okay. Also too, if it's advisory and it's put on the ballot, what happens if it passes?
Nothing.
Okay.
Advisory. Yeah. All right, last comment, Mr. Oxley.
You know, I've got an exact case here of property taxes that I took to the assessor's office today. It's a property in Lockport that last year was assessed at $65,000. They put a $25,000 addition on. And the assessed valuation went up to $103,000. So a $38,000 increase, or times three of $115,000 value increase to an attached garage on a property. How is that fair? And I've got all the paperwork here to prove it. That's what we're talking about.
Thank you. Roll call, please.
Richmond, Williams, Butler, Freeman, Hickey, Newquist, Oxley, Trinier, Winfrey, Van Dyne.
No.
Motion fails.
Motion fails. Looking for a motion to approve the county board agenda as amended. Motion by Hickey, second Winfrey. Roll call, please.
Richmond, Williams, Butler, Freeman, Hickey, Newquist, Oxley, Trainier, Winfrey, Van Dyne.
Yes.
Motion carries.
Motion carries. Next meeting is scheduled for September 10th, 2026. Motion to adjourn. Move Winfrey. Second Williams. All those in favor, please say aye. Aye. Anyone opposed? Motion carries.